Good morning, everyone. Welcome back to our weekly webinar series. There was a slight technical issue because of which we're starting a bit late. Over to Anil sir.
And the subject that we have chosen today is the Mediation Act again. As you all know, that the Mediation Act, that we are taking it as a new opportunity for the profession, and the new professionals will be created, new organizations, entities will be created. And today, instead of going by clause, I would actually try to see how this Mediation Act is going to be important in future. What all different laws are changed along with this gazetted notification of the Mediation Act, where the enactment has been done. So I think the most important part is that I have a combination of material today. Partly it is PPT and partly that I would be referring directly to the Act and also directly to some other source of information that we have collated. So in the next episode, we would be focusing on the discussion papers, and in subsequent again we will continue with the Mediation Act, and that would be the time when we will actually understand how this Mediation Act will actually do the mediation. What would be the acceptability of those mutually agreed mediation agreements. So this is very, very important. That's like when I see various schedules to the Mediation Act, it is really eye-opening how the government is thinking to reduce the burden on the various courts and how the mediation can help the Indian judicial system in reducing their pendency. So the mediation has actually been totally bifurcated from arbitration. So the arbitration would be totally a separate judicial process, and mediation would be a separate process. It is not considered to be a judicial process, but any agreement mutually agreed between the parties that can actually get finality, and that will be registered in the court, and that actually will be enforceable in future. So that is where the beauty of the mediation is. So coming to this, Ankit, let us start our subject today. I'm sharing my screen, so give me a second. So there are various things that as I said, that the kind of as we have said, it is clause by clause deliberations on Mediation Act, and in fact we would be doing some clauses only. As I said, that this the Gazette notification was done on 15th of September 2023. The President accent was given on 14th, and this particular Mediation Act is going to be extended to whole of India, and international mediation is also included in this act. So there are 11 chapters, 65 sections, and 10 schedules. So we will be more focusing on the schedules today. And while as far as the sections are concerned, the section provides for the entire process of mediation. However, the present objective of this particular webinar is to create some interest in the public at large in the mediation subject as such. How this mediation subject is going to be important, that is the subject today that we are going to take up. So when we see the preamble of the act, the preamble of this Mediation Act is to promote and facilitate mediation, especially institutional mediation. Now, especially institutional mediation, that in that process we will also cover what kind of institutions are being created out of this particular act. You all have seen that the Insolvency and Bankruptcy Code has created a kind of like ecosystem, and that ecosystem included IBBI, IPEs, IPA, and then the insolvency professionals and the valuers. So all this kind of infrastructure, the ecosystem is also being created under the Mediation Act. Exactly in the same way, the way insolvency and bankruptcy law was implemented in India, that is the way this law is also going to be implemented. So the objectives can continue further: resolution of disputes, commercial or otherwise. Enforce mediated settlement agreements. Now, this is more important. Mediated settlement agreements are enforceable. These are enforceable in case it has actually been done through a regularized process. Provide for a body for registration of mediators. That is where the mediation Council of India comes. The mediation of Council of India has been proposed in this act. So that is the body which will uh, provide a body for registration of mediators to encourage community mediation. Like the community mediation is like the panchayat, that is also community mediation, the gram panchayat. So that also would be encouraged, and there is a possibility that in gram panchayat also this mediation act is applicable. Online mediation as acceptable and cost effective process, that is also possible, because online mediation is possible, online hearing is possible, online judicial processes are possible, online arbitration is possible. So therefore online mediation is also possible. That is what the act is facilitating. Matters concerning therewith and incidental thereto, that is the objective. Now the application of this act is, as I said, that it is as mediation conducted in India, then any of the following conditions are fulfilled if all or both the parties habitually reside in or incorporated in or have their place of business in India. The mediation agreement provides that any dispute shall be resolved in accordance with the provisions of this act. There is an international mediation also, and the international mediation says wherein one of the parties to the dispute is the central government or the state government agencies. This is where the applicability of the law is. So this is also applicable where where one of the party is the central government, state government, or agencies promoted and owned by the central government. Public bodies, corporations, local bodies, including entities controlled by government. So the mediation is also possible between the government authorities, state government, central government, local bodies, where the matter pertains to a commercial dispute. So then to any kind of dispute also, if deemed appropriate and notified by the central government or state government for resolution through mediation under this act, wherein such government or agency, public bodies, corporation or local bodies, including entities controlled or owned by them, is a party. So these are what is the where the act is applicable, where the act is applicable. So now coming to the commercial dispute. Commercial dispute is the first thing that is applicable, means a dispute defined in clause C of subsection 1 of section 2 of the Commercial Court Act. So commercial dispute as per section 2 subsection 1 of clause C of the Commercial Court Act, then I actually have taken out this. The commercial dispute means a dispute arising out of ordinary transactions of merchants. Merchants means any trading transaction, any buy and selling transaction. Bankers, financiers, and traders, such as those relating to mercantile documents, including enforcement and interpretation of such documents. Export or import of merchandise or services, that means it is applicable to import and export. That means it is applicable to parties not having the normal jurisdiction of India. Issues relating to admiralty and the maritime law. Transactions related to aircraft, aircraft engines, aircraft equipment, helicopters, including sales, leasing, and financing of the same, carriage of goods. See, all these are commercial disputes. Construction and infrastructure contracts, including tenders, agreements relating to immovable property used exclusively in trade or commerce, franchising agreements, distribution and licensing agreements, management and consultancy agreements, joint venture agreements, shareholders agreement, subscription and investment agreements pertaining to the services industry, including outsourcing services and financial services. So this is the definition given under the Commercial Courts Act. Mercantile agency and mercantile usage, partnership agreements, technology development agreements, intellectual property rights relating to the registered and unregistered trademarks, copyrights, patent, design, domain name, geographical indications, semiconductor integrated circuits, agreements for sale of goods or provision of services, exploitation of oil and gas reserves or other natural resources, including electromagnetic spectrum, insurance and reinsurance, contracts of agency relating to any of the above, such other commercial disputes as may be notified by the central government. And there is an explanation to that particular section. A commercial dispute shall not cease to be a commercial dispute merely because it also involves action for recovery of immovable property or for realization of monies out of immovable property given as security or involves any other relief pertaining to immovable property. One of the contracting parties is a state or any of its agencies or instrumentalities or a private body carrying on the public function. Now, up to this, now we have to see what is the scope of commercial dispute. What is the scope of commercial dispute? And all that I have read is all considered as commercial dispute. And the jurisdiction for all these disputes lies before the commercial courts under the Commercial Court Act. So this is something that we all must know, that what exactly that we are going to talk about. That means all that 1, 2, 3, see, like all these 22 clauses that we have read, it is all pertaining to commercial disputes and the commercial dispute. And then I will only go to immediately one another slide, one another document, which is the schedule. Now, the schedule which talks about the schedule 9 to the Mediation Act. The schedule 9 has actually been notified, but then, as you know, the government will notify section by section for the implementation of this particular act as it was done under the IBC. Now, in the Commercial Court Act, now this 9th schedule to the Mediation Act has also made some amendments to the Commercial Courts Act. In the Commercial Court Act, for Chapter 3A, the following chapter shall be substituted. So the Chapter 3A has been substituted completely in the Commercial Court Act, and it is the chapter which pertains to pre-litigation mediation and settlement. In this pre-litigation and mediation settlement, one thing that I am trying to say, it's very, very important that a suit which does not contemplate any urgent interim relief under this act shall not be instituted unless the plaintiff exhaust the remedy of pre-litigation mediation in accordance with such manner and procedure as may be prescribed by rules made by the central government. For the purpose of pre-litigation mediation, the central government may by notification authorize the authority constituted under the Legal Services Authorities Act 87, because the Legal Services Authorities Act is not being repealed. Second, a mediation service provider as defined under clause M of the section 3 of the Mediation Act. In my last episode, I said that under this Mediation Act, a mediation service provider would be set up and would be approved by the Mediation Council of India, and let's call it MCI, Mediation Council of India. So that MCI will approve a mediation service provider, MSP. Now this MSP would be the pre-litigation authority. Once it is approved, then no commercial dispute can go to commercial courts unless there is any urgent interim relief required. And once that urgent interim relief is granted, again it will come to mediation. However, if a suit is filed before the commercial court, the first question will be asked whether you have gone through the mediation or not, and that too through a mediation service provider. So what exactly I'm trying to say, that most of the disputes before the Commercial Court Act will first have to go through the mediation threshold. Once the mediation threshold is covered, once the mediation is successful, now there are two options now. Once the mediation is successful, now it says if the mediation is successful, this same shall be reduced in writing and shall be signed by the parties and the mediator. The mediated settlement agreement arrived at under this section shall be dealt with in accordance with the provisions of section 27 and 28 of the Mediation Act. So that means that will be registered, that will be binding on both the parties, that will be even if the properties are transferred in the family settlement, those actually will be binding on the parties, because this has a judicial stamp. This will get a judicial stamp. So, Ankit, what I'm trying to say is that unless an urgent interim relief is required, the commercial court will ask you whether that you have gone through the threshold of mediation. The mediation will, it will be from 120 days will be given to the mediation. It can be extended by 60 days with the consent of both the parties. And like this particular period, whatever is spent through the mediation, that will not be even counted for the purpose of the limitation. Now, the whatever agreement has actually been entered, that will be dealt with. Then we will come to when we will study the clause by clause section 27 and 28 of the Mediation Act. So that also, so one part that today I am trying to say, the the most of the disputes where we have seen 22 clauses, where the jurisdiction lies with the commercial court, those in all those disputes, a threshold of mediation will have to be crossed. A suit which does not contemplate any urgent interim relief under this act shall not be instituted unless the plaintiff exhausts the remedy of pre-litigation mediation in accordance with such manner and procedures as, see, this is actually very important part of the Mediation Act. Now, Ankit, going forward, is there any question till now? Because see, this is something which is very important part of the. I'm trying to create an interest in this law. This is a law which actually is going to be much bigger than any other law.
So one of the questions that has come in is that Rajesh Kurup ji is having a comment. He says that even otherwise, Section 12 of the Commercial Courts Act mandates a pre-litigation mediation. So this is his opinion. Maybe we can confirm
No,
that.
this is absolutely right. So
Yeah.
there are two things that we are saying, that the Arbitration and Conciliation Act is deal with a particular part, and that part is also dealing with conciliation part. Now, I will come to that particular amendment also, and that particular amendment says that the arbitration will be totally different and the conciliation will come to this mediation. The conciliation will come to this mediation. I think with this question, now we can even go to the other the other part of the important the amendment, and that amendment is the sixth schedule to the Mediation Act. Now, the sixth schedule to the Mediation Act, that makes an amendment in the Arbitration and Conciliation Act 1996. It says that in Section 43D, in the Arbitration Act of Section 43D, the words mediation, conciliation shall be omitted. That means that from the arbitration and conciliation, that particular Arbitration and Conciliation Act would be restricted to arbitration. And the next part. In subsection 2, in clauses E, F, and I, the words and conciliation, wherever they occur, shall be omitted. So that means that the arbitration and conciliation will be reduced to arbitration, and the conciliation will actually become to mediation. This is what is my understanding. And then what? Again it says the reference of the conciliation in enactments. Any provision in any other enactment for the time being in force providing for resolution of dispute through conciliation in accordance with the provisions of this act. This act means Arbitration and Conciliation Act, shall be construed as the reference to mediation as provided under the Mediation Act. So the entire Arbitration and Conciliation Act, any other enactment where the conciliation or resolution of dispute through conciliation is mentioned, that will be considered as if it means Mediation Act, and will not mean as if it is Arbitration and Conciliation Act. Again, the conciliation as provided under this Act and the Code of Civil Procedures 1908 shall be construed as mediation. So that means the Code of Civil Procedures also, where the conciliation is used, that will also be construed as mediation. Now, but then one thing that they have given in this particular law that whatever mediation or conciliations are continuing under Arbitration and Conciliation Act, that will continue considering as if this Mediation Act has not been enacted. So this is not applicable to past proceedings under the conciliation part of the Arbitration and Conciliation Act. So the conciliations which actually have already started would not be brought to the Mediation Act. So this is what is this part is very, very important, that we also understand that the arbitration and conciliation and the mediation part is now, the mediation also would be a kind of regulated profession. So Ankit, so we have seen the one opportunity under the commercial code. Now the second opportunity is under the MSME Act, Micro, Small and Medium Enterprises Development Act 2006, and this is in the part 7th schedule of the Mediation Act. In this, the section 18 has been substituted, section 18 of MSME Act has been substituted, which says reference to MSME Council, reference to Micro and Small Enterprise Facilitation Council, notwithstanding anything contained in any other law for the timing in force, any party to a dispute may regard to any amount due under section 17 make a reference to Micro and Small Enterprises Facilitation Council. Now, what it says in subsection 2, on receipt of a reference under subsection 1, the council shall either conduct mediation itself or refer the matter to any mediation service provider as provided under the Mediation Act. So this is a change. Third, the conduct of mediation under this section shall be as per the provisions of the Mediation Act. This is the third. Fourth, where the mediation initiated under subsection 3 is not successful and stands terminated without any settlement between the parties, the council shall either itself take up the dispute for arbitration or refer it to any institution or center providing alternative dispute resolution services for such arbitration, and the provisions of Arbitration and Conciliation Act shall then apply. So the first process is mandatory, that is mediation. After the mediation fails, then it will go to arbitration. And after so that is what is the what I'm trying to say. In the 7th schedule, the MSME Act had been changed, and the most of the disputes under the MSME, which is usually referred to the Facilitation Council, that will have the first threshold of crossing the mediation. That mediation can be done by the council or it can be referred to the mediation service providers. So this is another opportunity which will actually come to the mediation service providers or the mediators. That's something which is, again, I want to say. Now the other part is the Companies Act. Now through this Mediation Act, the central government have also, through this 8th schedule, have also substituted section 442 of the Companies Act. Now, in this particular act, in 442, already it was mentioned as reference to mediation. Now let us read the amended section. Any of the parties to a proceedings before the central government, tribunal or the appellate tribunal. When I say central government, that means any dispute before the registrar of companies, any dispute between before their directors, any dispute before the NCLT, because that's tribunal, any dispute before the NCLAT, because that is an appellate tribunal. So these are the authorities. These are the authorities any of the parties may at any time apply to the central government, tribunal or appellate tribunal, as the case may be, in such form. So the form will be provided along with a fee as may be prescribed for referring the matter pertaining to such proceedings for mediation. And the central government, NCLT, NCLAT shall, the word written is shall. So if there is a dispute regarding shareholding, if there is a dispute regarding operations and mismanagement, if there is a dispute regarding directorship, dispute regarding shareholding, all this basically under the Companies Act, which normally goes to either the central government, means the registrar of companies or regional directors, or it goes to NCLT, or it goes to NCLT, that shall, once the application is made by the party, shall refer the matter to mediation under the Mediation Act. Now, second, nothing in this section shall prevent the central government, NCLT, NCLAT, before which any proceeding is pending, from referring any matter pertaining to such proceedings suo moto to mediation to be conducted, even if no party has made an application, even if no fee has been deposited. The registrar of companies, regional directors, they all have powers, NCLT, NCLT, they all have powers to refer the matter to mediation under the provisions of the Mediation Act. Now, the mediator or the mediation service provider shall file the mediated settlement agreement arrived at between the parties with these authorities, and then shall these ROC, regional director, NCLT, NCLAT shall pass an order or judgment making the said mediated settlement agreement as part thereof. Final judgment will come. This mediated settlement agreement will be part of that judgment, and the dispute is concluded. The final order is enforceable on both the parties or all the parties. So what we understand, that most of the petty disputes, most of the disputes where if the court is not able to provide that much of time, if the case is complicated, the court will suo moto refer it to mediation. Or in case the parties apply for a faster, resolution, they can also immediately submit a fee, and then in that case all these tribunal, appellate tribunal, regional director, ROC, they will not have an option. They shall refer the matter to mediation. There is no power with them to say no. So this is another opportunity which actually is coming to the mediators, mediation service providers. Ankit, is it correct? I think you think that whatever I'm saying is okay. You
Yes,
like
yes,
to add
yes.
something?
No, that's perfect. So I think this is the interpretation that I would also have.
So now coming again to the we have seen the arbitration. We now will go to the Legal Services Authorities Act 1987, and there is an amendment in section 4 of clause F. The following clause shall be substituted. Now, in this case, the mediation word has been added. Encourage the settlement of disputes, including online. So, one is the online has been facilitated by way of negotiation, arbitration, mediation, and conciliation. So, the mediation has been added in the fixed schedule in the Legal Services Authorities Act. Now, this is again something which is the Code of Civil Procedures. Code of Civil Procedures. So, Ankit, this is again under Part 5, under the heading Special Proceedings, the subheading Arbitration shall be omitted. Now, what is now coming for the section 89? The following shall be substituted in the Code of Civil Procedure. The section 89 says settlement of disputes outside the court, where it appears to the court that dispute between the parties may be settled and there exists elements of settlement which may be acceptable to the parties. The court may, 1, refer the dispute to arbitration, and thereafter the provision of Arbitration and Conciliation Act 96 shall apply as if the proceedings of arbitration were referred for settlement under the provision of that act. Or B, refer the parties to mediation to the court annexed mediation center or any other mediation service provider or any mediator as per the option of the parties. As per the option of the parties, and thereafter the provisions of the Mediation Act shall apply as if the proceedings for mediation were referred for settlement under the provisions of that act. And third is the Lok Adalat. And fourth is the effect compromise between the parties and shall follow such procedure as deemed fit for the judicial settlement. So this is also an amendment in the Code of Civil Procedure. Now, in Indian Contract Act, in the third schedule, in the Indian Contract Act, they have also made some amendment that actually will mean that if that particular agreement or a contract, if any of the party is ready or is trying to refer it to mediation, that will not have any adverse impact on the agreement. So in case the mediation fails, so those agreement, the valid agreements under the Indian Contract Act, those will not be adversely impacted. So therefore the Mediation Act actually is being given a lot of power. So after the commercial code, Ankit, now we have to see the 10th schedule, which is the Consumer Protection Act. Now, in this case, one that some clauses are being omitted, and will come into the detail. But then the section 17, the following section shall be substituted, namely uh, section 37, reference to mediation. Now, this section has been now newly substituted. The district commission or the state commission or the national commission, as the case may be, shall, either on an application by the parties at any stage of the proceedings, refer the dispute for settlement by the mediation under the Mediation Act. Now, section 37A, settlement through mediation. Pursuant to mediation, if an agreement is reached between the parties with respect to all of the issues involved in the consumer dispute, or with respect to only some of the issues, the terms of such agreement shall be reduced to writing accordingly and signed by the parties to such dispute or their authorized representative. Then the mediator shall prepare a settlement report of the settlement and forward the signed document along with such report to the concerned commission. So, where no agreement is reached between the parties within the specified time, or the mediator is of the opinion that settlement is not possible, he shall prepare his report accordingly and submit the same to the concerned commission. When is the recording settlement and passing the order? The district commission, state commission, or national commission, as the case may be, shall within 7 days of the receipt of settlement report pass suitable order recording such settlement of the consumer dispute and dispose of the matter accordingly. So now let us understand, if the mediation is ordered, mediation will take 120 days and it is extendable by further 60 days. And finally, when the report is submitted, the commission shall pass within the order of within 7 days. So expedition of any kind of dispute is also possible. So there is a huge backlog before the district commission, state commission, and the national commission. So in case this Mediation Act can help, so I think that is also something that we wanted to say. So we have now seen the 10th schedule that actually is about Consumer Protection Act. We have seen the commercial code. So huge case from commercial court is likely to come. Then we can see the Companies Act. There can be huge cases of Companies Act disputes can come. MSME also can actually be brought into the mediation. Arbitration is totally segregated. Conciliation is totally merged with the mediation. So the mediation is totally separate now. Arbitration is totally separate. Arbitration order can be enforceable on the parties, whereas the mediation agreement is only enforceable when both the parties sign. Legal Services Authorities Act, they also say that this particular act will also continue, but they will also have the mediation part of it. So the Civil Code of Civil Procedures have also added accordingly. The Indian Contract Act is also amended, and second schedule. So these are some of the laws, these are some of the enactments which are considered to be having the priority over the Mediation Act. So these are like 9 enactments. Otherwise, the Mediation Act is overriding on all other laws of the country, all other enactments of the country. However, these are the enactments which are not having a kind of these are the superior over the Mediation Act. So in case anything is mentioned in these acts, like the Industrial Dispute Act, the Brahmaputra Board Act, the Cine Workers and Cinema Theatres Workers Regulations and Employment Act, the Family Court Act, the Legal Services Authorities Act, the Maintenance and Welfare of Parents and Senior Citizen Act, the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act, the Finance Act 2016, the Industrial Relations Code 2020. So these are some of the uh, acts where the government probably thought that the Mediation Act can be misused. So these acts would have an overpowering authority on the Mediation Act. So these acts are excluded. So not that the dispute, but then in case something is written, so these acts are excluded. Then there are some kind of disputes which are not possible to resolve through mediation that we covered in the last uh, part of our webinar also. But in this part, we would say that this is also important, that we should see what is not covered under the mediation. So the one is dispute which may be by virtue of any law for the time being in force may not be submitted for mediation. The like try to see this kind of the rights of persons with the disability act, mental health care act. So any person who is not having a sound mind, the mediation is not possible with that man. Disputes involving prosecution for criminal offenses, that is not possible to mediate. Now, the complaints or proceedings initiated before any statutory authority or body in relation to registration, discipline, misconduct, or any practitioner or other registered professional such as legal practitioner, medical practitioner, dentist, architect, chartered accountant, or in relation to any other profession of whatever description which is regulated under any law for the time being in force. These are the complaints against them. Disputes which have the effect on rights of a third party who are not a party to the mediation proceeding except only in matrimonial disputes uh, where the interest of a child is involved. Then this National Green Tribunal proceedings, then any dispute relating to the levy, collection, penalties, or offences in relation to any direct or indirect tax or refunds enacted by the central government or state government or parliament, anything like Competition Act, so the Telecom Regulatory Authority of India, then the proceedings before appropriate commissions and appellate tribunals for the electricity under the Electricity Act, Petroleum and Natural Gas Regulatory Board, SEBI, land acquisition and determination of compensation. These are the issues which cannot be mediated because these are the issues which requires enforceability, which are basically not possible to be handled through the mediation part. So, Ankit, when we see these schedules from 1 to 10, so first of all, our main objective is to create an interest in clause by clause reading of the uh, law. Now we have to just see what exactly we are talking about the mediation institutions. So like I have this like as I said, this the what kind of ecosystem will be developed. What kind of ecosystem would be developed? One is the uh, community mediator, means a mediator for the purpose of conduct of community mediator under chapter 10. We will discuss when this chapter 10 will come, how the community mediator will be uh, accredited, how they would be approved. Then is the council. The council is very clear as per section 3, subsection C of the Mediation Act. The Medical Council of India will be established. Then is the mediator. Mediator means a person who is appointed to be a mediator, a person registered as a mediator with the council to undertake mediation by the parties by the mediation service provider. Now, the explanation says that where more than one mediator is appointed for mediation, reference to mediator shall mean reference to mediators. Now, this is another institution, this is another opportunity that I'm going to talk about now. This section 3, subsection 1 says the Mediation Institute means a body or organization that provides training, continuous education, and certification of mediators and carries out such other functions under this Act. Now, this mediation institution also would be created so that those mediation institutions will provide training, they will provide continuous education, they will provide certification to the mediators, and will carry out all the functions as provided in the Act. We'll come back to that. Now, the section 3, subsection 5 also creates mediation service providers. And the mediation service providers, like we see, the mediation service providers, the definition says that it includes a body or an organization. That means it can be a private limited company, it can be a partnership firm, or it will depend upon the regulations that provides for conduct of mediation under this act and the rules and regulations made therein and is recognized by the council. An authority constituted under the Legal Services Authorities Act, a court annexed mediation center, any other body as may be notified by the central government. So when this new opportunity will be come up, the new opportunity will be called MSP, Mediation Service Provider. We are still waiting for the regulations and the rules. The one is the body which will be freshly incorporated under this Mediation Act as approved by the Council, Mediation Council of India. And there are already some authorities which has been constituted under the Legal Services Authorities Act. Under the Legal Services Authorities Act, those have been constituted. And there are some court annexed mediation centers. Court annexed mediation centers are also there. And any other body as will be notified by the central government. So that is something which are presently, so when these mediation service providers will be constituted, so they would be competing with the court annexed mediation center and also the Legal Services Authorities Act, the authorities constituted under that act. Now the other is the like participation and the party is some of the definitions. Now let us understand the role of the mediation service provider. The mediation service provider, their role is first of all, the mediation service provider shall be recognized by the council and the rules will be specified. The council will provide regulation procedures and process for the registration of mediation service providers. Now their functions are, one function is accredit mediators and maintain panel of mediators. So we actually have to see, because for the accreditation of mediators, what kind of organization would be required, whether the private organizations can really function or it would be some organizations which are somehow controlled by government, because this particular organization would be having the power to accredit mediators and maintain panel of mediators, then provide the services of mediators for conduct of mediation, then provide all facilities like secretarial assistance and infrastructure for the efficient conduct of the mediation, then promote professional and ethical conduct amongst mediators, facilitate registration and mediated settlement agreements in accordance with provisions of Section 20, and such other functions as may be specified. So these are the functions of MSP. Now, Section 42 further says the Council shall recognize mediation institutes to perform such duties and exercise such functions as may be specified. Now, coming to the mediation institutions. Now, the definition of mediation institution says the mediation institute means a body or organization that provides training, continuous education, and certification of mediators and carries out such other functions under this Act. The functions of mediation institution and monitoring by council, this is what I'm saying. The continuous education, certification, and assessment of mediator is the function. So I think the also Mediation Institute will also try to hold training workshops. They will also conduct courses. They will also have some kind of affiliation with the law firms, with universities. The mediation institutions will also be recognized by the council and would be subject to renewal, withdrawal, suspension. The council will also specify some criteria for recognition of mediation institutions. The council can also call for information and record the mediation institutions. So these are mediation institutions that actually will be there in the ecosystem. So what we also have seen that in this entire act, as may be specified word is written at many places. So wherever the as may be specified word is written, that means that the regulation will be framed for that particular part where the word specified is written. Now, wherever the word prescribed is written, that means that the Ministry of Law, central government will provide for rules. So these are still awaited. These are still awaited. And once we see that these are awaited, probably the regulations and rules certainly will provide us the greatest clarity about how this Mediation Act would be functioning, how the uh, accreditation would be done for the mediation, what is the basic criteria for the mediation. So all this will be done based on the all this will be done based on the regulations and the rules. So Ankit, in case there are questions, so today we would like to just restrict ourselves to this part only. We wanted to say that the most of the disputes under the Consumer Protection Act, MSME, the Commercial Court Act, all and the Companies Act, those are likely to be, those are likely to cross the threshold of the Mediation Act, and this would be a huge opportunity for the professionals. So in the coming period, we would also be discussing. But then I think we can take up some questions, Ankit, now. Because going, first of all, it is important that we should create importance, we should create interest in clause by clause understanding of this law. Then only we will go clause by clause. So the today's focus was only to create an understanding how the Mediation Act would finally find the clients and how would the professionals will take it as a main profession. Yes, Ankit.
So question from Mika Beer. Mika Beer ji is asking, when a contract is having a mediation clause, can the parties directly go for mediation without going through the commercial courts in the event of a dispute? I believe that is the intention, that the
It is the
mediation
intent.
can start. Yes, that is the idea. Well, before going to the courts, we go for a mediation. That's the idea.
Unless there is any urgent interim relief is required.
Right. So who can be the mediator? That I believe is a question that will be answered once the rules come out. But broadly, we know that the mediator is somebody who will be either empaneled with any of these agencies or recognized by the mediation council that will be set up later. Then there is a question which says, is there any provision regarding proceedings in DRT, DRAT, or under IBC for mediation related in the Mediation Act? Any specific provisions for DRT, DRAT, or IBC?
No, we have seen in our presentation that the definition of commercial dispute, the definition of commercial dispute is very, very enlarged. So when we see the commercial dispute, so we actually have seen the commercial dispute is a very, very big definition. So in case we see the commercial dispute definition, I think it is huge. So we have already gone through that commercial dispute. So I don't think we should repeat that. So we,
Right.
yeah, in the commercial dispute, we also have seen the borrowing, the loan, everything can be routed through the, unless the specific jurisdiction of DRT is there.
So Prashantji is asking if Schedule 8 has been notified. So in our opinion, Schedule 8 is yet to be notified. But under
All
this
the
act,
everything
yeah,
else, everything.
all
No. Only the gadget of this law has been done. The uh, notification for each section will be separate,
yes, and that is
and
still
that will
pending.
come once the mediation council of India
Yeah,
is.
so the government will basically put some homework behind the by setting up that council, and then that's how IBC also was happened, where
Yes.
they invoked some notified some sections where the IBBI was formed first, then they prepared all the rules and so on. So that's how it will work here as well. Can a dispute under SARFAESI Act be referred to Mediation Act? So when we
No, I
talk about
don't.
a dispute under SARFAESI Act, we are rather talking about the provisions. I believe Arun Srivastava here is asking if the enforcement of security can be put into a dispute. So enforcement of security under SARFAESI Act is a rather a pure right under the SARFAESI Act which is given to the mortgager, which is the mortgagee, and there going to DRT would be the only solution to stop that action. You can't go to mediation and say that the SARFAESI action is stopped or paused.
Yes, SARFAESI is a separate jurisdiction. SARFAESI has a adjudicating authority as DRT, and once a particular case falls under that particular jurisdiction, I don't think the mediation is any part of that.
Yeah. Whether mediation will be available after admission of CARP. So when you say mediation, we are talking about mediation as a CD. So as a CD, as an RP representing the CD, there can be a mediation that is possible. With respect to mediation with COC members,
We have not seen any amendment in the Mediation Act, which is the amendment in the Insolvency and Bankruptcy Code. We are expecting that when these amendments will be done to Insolvency and Bankruptcy Code, in that code itself, the Mediation Act will be referred at various places so that the NCLT is not overburdened and uh, most of the disputes are resolved through the Mediation Act. But then we are expecting amendments in the Insolvency and Bankruptcy Code to that extent.
so apart from this, we have qualification to practice as a mediation for Mediation
Not
Act.
yet
I think
clarified.
we will
Not yet
see.
clarified.
So we will see when it comes the notification, and I believe, yeah, there's a question that what is the threshold and what would be the threshold limit. I think we must have talked about the threshold, so that's
So
the
there is
question
no
as well.
threshold limit as such provided in
Hmm.
the Act. We have seen that, and the threshold limits of different acts that may be applicable once the regulations and rules are notified.
Right. So I believe that's about it. These are the questions that I could observe are, unique questions.
So fair enough, Ankit. So to our audience, to our well-wishers, we can only say that the insolvency and bankruptcy law also came like this, and we got the advantage of being the early birds. So I would advise my our audience, our uh, listeners, that uh, they can also start reading about this act, and we should make some groups, WhatsApp groups or Telegram groups. We should also make some kind of LinkedIn groups where the discussions on this Mediation Act can benefit all the interested persons. So this is where we actually would like to say that this is going to be again a law which will see a great heights in the coming years. Thank you very much for.
Just wanted to add that today morning we got these two discussion papers that came in, so like that's on liquidation and how the IPE would there are changes in how the IPE will work, and that's the discussion paper. So maybe the next week we will keep a session for that and understand the changes in the both the changes proposed in the discussion papers, and we'd like to have an interactive session then, so we can do that.
So thank you very much. So we conclude the like this our 80th episode today, Ankit. We
Yes,
conclude with
yes.
thanks to all the participants. Thank you very much.
Thank you, everyone. Thank you.